Good afternoon, everybody, and thank you very much for coming along this afternoon. And thank you, Chair, for the introduction. My name is Liz Griffith, and I work at Law Centre NI in Belfast. I am going to speak today to give you a bit of a set the scene a little and provide some context about the key asylum policy issues that we're grappling here in Northern Ireland. So just to get us started, a little bit about some stats. This is all caveated with the fact that we don't have the full picture of asylum data. The Home Office, which is the agency responsible for asylum, doesn't routinely publish detailed regional asylum data. But what we do know is that there are quite a few more than 1,000 asylum seekers who are currently in receipt of asylum support in Northern Ireland, and all of that official asylum support is provided in Belfast. And asylum support here consists of shared accommodation if you're an adult, and just under £40 per person per week in subsistence. In addition to those who've come through the asylum process, in the last 5 years, almost 2,000 Syrian refugees have arrived through a resettlement programme. This is the first time Northern Ireland has been involved in a resettlement programme since the late 1970s, when some Vietnamese families arrived. Regrettably, immigration detention remains a feature of the UK asylum system. There is a small detention centre in Larne, which is just north of Belfast, and it can accommodate up to 19 people. To give you a little context, just to set out that immigration is an accepted matter. So what that means is, according to the Northern Ireland Act, Westminster always has responsibility for immigration policy, although the Northern Ireland Executive Office is very clear in the racial equality strategy that although Westminster makes the policy, the effects of those policies are felt locally. And the executive is clear that it does have responsibilities and powers for areas of law that are relevant for people subject to immigration control. And the Executive Office has been clear that there will be times, and there are times, that Northern Ireland's regional immigration interests will not coincide with those of Great Britain, and therefore it is legitimate and right that it does take a different path at times, perhaps not to the extent that the Scottish Government has done so, but we have seen different approaches. And a relevant example here is that immigration law broadly remains in scope for legal aid in Northern Ireland, whereas of course it is broadly out of scope in Great Britain. So what are the big issues as a result of Brexit? All of the common European asylum system, that has fallen away. And so, as of the end of the transition period, the Dublin regulation no longer applies. And you will be hearing a lot about the Dublin regulation this afternoon, but in essence, it's the mechanism whereby the relevant EU member state that's responsible for examining an asylum claim can be identified. And it's the framework by which then asylum seekers can be moved by the member state from one jurisdiction to another. Of course, this is particularly relevant. It has been particularly relevant on this island, given the movement of some asylum seekers from south, north, and vice versa. So the Dublin regulation has gone, and in its place, a new inadmissibility procedure is now in place by virtue of brought in by the immigration rules. Very briefly, it means that all new asylum applications are first screened. They are subject to an inadmissibility sift, and that's the Home Office terminology, whereby the Home Office will try and determine if there is another country that can deal with that asylum application. They will then issue a notice of intent to the individual. We intend to remove you. That will be followed up by a decision in principle. And then finally, the person will be removed to a safe third country. And I think what is particularly striking, and no doubt you'll hear more, is that the UK's definition of a safe third country is really, really wide. So it's any country that the asylum seeker has travelled through, any country that the person has any connection to, or any country that the UK has secured a returns agreement with. Now, I thought you might be interested in some data on this. So in the first quarter of this year, the Home Office have issued 1,500 notices of intent to remove people, but in actual fact, it hasn't removed a single person under this new procedure. And in contrast, in the quarter one of the preceding year, about 200 people were transferred in and 30 odd people were transferred out. We tried to obtain inadmissibility data for Northern Ireland, but it's not available. Just wanted to flag some other big issues that are looming for practitioners here, and that is really the implementation of the new plan for immigration. This is the Home Office proposals came out for public consultation recently and are likely to be then implemented through the Sovereign Borders Bill. It contains very draconian proposals from a refugee rights perspective, such as denying refugee status to persons who enter the UK unlawfully. So a real departure we would see from the Refugee Convention, a proposal to set up reception centres. That is particularly a troubling idea. And we're also aware that, it would be extraordinary if Northern Ireland were to develop a system of reception at exactly the same time that the Irish government is committed to abolish direct provision. The new plan also envisages lots more criminal penalties to do with stopping, searching and seizing vessels and vehicles. There's no consideration in the Home Office plans as to what this will mean in the land border context. It contains a new requirement for everyone to act in good faith. This applies to the legal profession too, and this is particularly contentious, as you can imagine, and a number of other changes to envisaged. If you were interested, there's a couple of some bedtime reading for people where we've attempted to identify the impact of what this plan will mean here. The Refugee and Asylum Forum, the Children's Law Centre and the Northern Ireland Legal Practitioners Group have all put together responses and they're available. And then finally, some other issues that refugees in Northern Ireland are grappling with, and therefore by extension, their legal representatives too. Obviously, with the end of the Dublin regulation, on the one hand, it means it's more difficult for the UK to remove people out of the UK, but it also means it's much more difficult for families to be reunited, and specifically routes for unaccompanied minors who are stranded in Europe now, finding it even more difficult to be reunited with family members here. Other issues are due to the relaxation of, or the soon to be relaxing of the COVID measures. We're going to see an imminent cessation of asylum support. That's really a euphemism for saying that a number of people are going to be made homeless when they are evicted from their asylum accommodation. Ongoing issues are, the practicalities for refugees wanting to travel on the island of Ireland. We're very much mindful that there has always been a hard border for refugees, but now that there's an official hard border, we're worried about the increase in racial profiling and just some of the practical difficulties of refugees having to get visas to travel a couple of miles north or south across the border. And all of these issues that I've identified are all happening in the context of an increased demand for immigration advice due to the increased number of asylum seekers at a time when the legal profession here, has ever diminishing capacity to provide advice. So, Chair, I'll stop there.
Thank you very much, Liz. Excellent and troubling as well to hear some of that. We're now going to move on to Nick Henderson from the Irish Refugee Council. Nick.
Thanks very much. A year into the pandemic and I'm still forgetting to unmute myself. Can you all see my screen there? Okay, yeah, I think you can now. So thanks very much, everybody, for coming, and in particular to our guest speakers, to Colin for chairing, Adrian, Trish, and also to Liz, who's put a huge amount into organising this, and we're really grateful. I only have 2 slides today, and I'm going to speak with little detail, but just to flag in bullet point form some of the issues that we see now, but also that we see may emerge in the future as a result of the United Kingdom leaving the European Union, and how that affects international protection policy in Ireland, in the Republic. The first point is around a broader definition of inadmissibility, and Trish is going to talk us through that in more detail. So I'm not going to cover it, but only to say that that is a considerable broadening of that definition, and on each reading it seems to get even broader. And it is worth noting as well that that was put through the Dáil, that amending piece of legislation was put through the Dáil in December with little or no scrutiny. And we as an organisation, and I'll admit that we may have dropped the ball slightly on that, we were really only aware of it until it was halfway through the legislative process. So with that as well, there is an issue around an interpretation of inadmissibility. And I've tried to put this as concisely as possible, but is your application inadmissible when recommended to be so by the International Protection Office, or only when determined to be so by the Minister? And we take the view that the inadmissibility process is one over a period of time, and you only have an inadmissible protection application when the Minister determines you to be so. And up until that point, you are still a protection applicant, and you still have an entitlement to reception conditions. And the International Protection Office and the Irish government take the different view that when the International Protection Office recommend you as having an inadmissible protection application, that's that. You can go no further. And that has huge consequences, and it's an active issue on which we're in correspondence directly with the Protection Office about at this time. One thing to say, and I think Trish will cover this as well, is that we've gone from a situation where if for transfers between the UK and Ireland, we had the Dublin regulation, which was 20 years of text, 3 iterations, jurisprudence from the Court of Justice, and it's now been dissolved, and Trish again will mention this, I think, to a handful of pages, if that, in terms of the amending legislation that was put through in December of this year. That amending legislation also made the UK a safe third country from the perspective of Ireland, and there's, along with a list of several other countries, including Georgia, Albania, South Africa, and others. I think Adrian may mention this in his piece, but it is of note and interesting that the UK has struggled, I think, if at all, able to make any bilateral agreements with other member states around returns post-Brexit, but presumably Ireland is one member state that has a form of bilateral agreement. So those are some issues around inadmissibility and the sort of the mechanics of the protection process. And in my second slide, I'm going to talk a little bit about slightly more peripheral issues that may not be so material now, but certainly maybe in the future. The first one is material now, and it's what Liz very eloquently described, which is there has always been a hard border between the north and the south, and the east and west. If you are a person seeking protection living in Dundalk at the moment and you wanted to go shopping in Newry, you would have to get the consent of the minister to leave and presumably a visa, otherwise you're committing a criminal offence. If you're a refugee, you have to get a visa from the UK embassy in Dublin. And with Brexit, presumably that border is only made even harder. And this, and Colin, I'm sure, might have some observations on this as well, is this seems to be inconsistent with an increasing move to a sort of shared island dialogue, an inclusive conversation about how we share our island on into the future, that there is, for a significant group of people, there is a very real hard border. Taking a more sort of distant look back on Irish asylum policy and protection policy, we've traditionally always had some sort of alignment with the United Kingdom, and this has been given as a reason why we wouldn't opt into the array of European Union directives and regulations around protection. Will that change post-Brexit? Perhaps. The Catherine Day Advisory Group recommended that Ireland would adopt, those new texts that are under discussion in Brussels at the moment. I haven't seen, and people may correct me on this, I haven't seen that I know that we know that recommendation wasn't adopted within the white paper that was published at the end of February, and I haven't seen any other discussion around it. That's not to say it isn't in the thinking of policymakers here, but it is notable. One point that I think is worth reflecting on, and a quick Google search demonstrates this, is that there was several stories, often using quotes from civil servants in recent years, how Brexit would result in an increase in the number of people seeking asylum in Ireland. And that isn't reflected in the number of people seeking protection in Ireland in 2020, nor in 2021 so far. Only 618 people in 2021 so far. That's not to say that those figures aren't slightly distorted by the pandemic, and that the figures generally have gone down, but it is worth reflecting on, and that anticipated spike or rise that was commonly reported on has not yet materialized. And then finally, just again, some reflections, and Liz mentioned this, is that there is a divergence also on how the two states are approaching accommodation. In Ireland, we have a white paper that commits to ending direct provision in congregated settings. There's a long, long way, as we all know, about that being implemented in full, but that is government policy. Meanwhile, in the UK, as Liz said, their new policy document states that reception centres there'll be a shift to using reception centres to provide basic accommodation while processing the claims of asylum seekers. And it's interesting that in some ways we would be looking for the two jurisdictions to learn positively of each other's mistakes, but that may not be happening. We have another seminar tomorrow afternoon, actually, which you can attend and register for, just if you look on our social media, on implementing alternatives to direct provision. And we have a speaker from the UK who will be reflecting on some of this. So, Chair, that's just some reflections from and observations from our side, and I'm sure Trish will give us a proper deep dive into the real mechanics of this.
Thank you very much, Nick. Very much appreciated. Again, fascinating contribution there. You know, a number of themes that stood out. The real tensions that are going to emerge in the relationship between the UK and Ireland in a post-Brexit context. The sense in which there's already a hard border on the island of Ireland for some people, and where this all might go in the time ahead in relation to the shared island dialogue. And I suppose what strikes me is this needs to form part of that conversation, and it's great to see this event today. So thank you both very much. Now going to hear testimony of the lived experience. The next session that we're going to be moving into now is looking at developments in the south of Ireland, and we're going to hear more about the ongoing plans in the UK in the post-Brexit context. Our first speaker is Patricia Brazil, who's going to be speaking to us on expanded inadmissibility procedure and the new return order procedure. Patricia is the Averil Deverell Lecturer in Law at Trinity College Dublin, where she lectures in refugee and immigration law, family law, and child law. She's also practiced as a barrister since 2004, specializing in the areas of asylum, immigration, family, and child law. And I'll now hand you over to Patricia. Thank you.
Sorry, thank you, Colin. I was just trying to bring up the slides. So thank you very much for your kind introduction, and thank you to the organisers for inviting me today. I will add my voice to Nick's comments that the revised arrangements in terms of it being inadmissibility procedure and the new return order procedure escaped my notice. I think if we were to forgive ourselves, we might say that that was partly because so much of the Brexit negotiations came so late in the day as to the detail, and the question of whether the UK would remain part of certain aspects of the CEAS, and in particular the Dublin regulation, only became clear, I think, quite late in the day. And therefore this legislation, the amending legislation, I think was very rushed through, and various issues, I think, perhaps didn't receive enough attention, both in terms of legislative scrutiny and also policy discussion and debate. So, sorry, I'm just going to try and make this appear as a slideshow. There we are. Okay. So, in terms of the background, I suppose I didn't think I could start this without referring to the debacle that has been the Dublin regulation in Ireland in the last 3 or 4 years. Although the whole system of Dublin transfers is premised on a fairly swift procedure for the allocation of responsibility for applications and transfer of applicants under those rules, because of various really very difficult to understand factors in Ireland, the Dublin system has barely functioned, largely due to particular issues around the Article 17 humanitarian discretion and the question of who had the authority to exercise the Article 17 power. The Minister for Justice initially denying any responsibility in open correspondence to the Legal Aid Board, and then for 4 years thereafter in litigation before the Superior Courts, maintaining that in fact it was the Minister who had that responsibility all along. That was only resolved finally last year with the Supreme Court decision in NVU siding with the Minister and finding that that was where the Article 17 discretion vested. But in the interim, the High Court was effectively granting global injunctions for the asking to Dublin applicants who were litigating in this on point and whose cases were awaiting determination. So we had built up, I think, quite a number of applications which were in the Dublin system but never actually completed or brought to a conclusion by the time the UK departed from the European Union on 31st of December. Because of the arrangements that are in place and the details of the negotiation, the Dublin regulation no longer applies in respect of transfers to the United Kingdom. And so the response taken by the Irish legislature was to expand the scope of the inadmissibility procedure. We already had an inadmissibility procedure in Section 21 of the International Protection Act, but it's been expanded effectively now to replace or take the place of the Dublin transfer mechanism in respect of people who have a particular connection to the United Kingdom. And also we've introduced now a new return order procedure that didn't exist in the legislation until very recently. So as I mentioned, and many of you will already be aware of this, but just to make sure everyone has the background, there were originally in section 21 two categories of inadmissible applications, where another member state had granted refugee status or subsidiary protection to a person, or a country other than a member state was a first country of asylum for a person, and the first country of asylum was effectively a country which had recognized a person as a refugee, that was still available to protect a person, and effective protection, including the benefit of the principle of non-refoulement, will be available, and that as a matter of practicality, the person would be readmitted to that country so that they could enjoy all of those protections. Certainly my own experience as a practitioner is that while there were applications being deemed admissible, these were relatively limited, these grounds applied in a relatively limited number of cases. The procedure for inadmissible applications was also set out in section 21, and actually I realised I should have had this on the slides, which I don't. The procedure itself hasn't changed post-Brexit, so the procedural rules still apply, it's just the substantive categories have been expanded. So the procedure is where a person has made an application or an indicated intention to apply for international protection in Ireland. If on examining that application, the International Protection Office, the IPO, forms the opinion that the application is inadmissible, they make a recommendation. The IPO makes a recommendation to the minister that the application shall be or should be determined to be inadmissible. And that's the language in the legislation, which I'll come back to because this is quite important. So it's a recommendation from the IPO. That comes in a written form, and that has to obviously be given to the person concerned and their legal representatives. That sets out the reasons for the finding of inadmissibility, along with notice of the fact that the person can appeal against that recommendation to the IPAT, but it's a limited papers only appeal, so there's no oral hearing. The IPAT under the legislation under section 21.9 can either affirm the recommendation that the application is inadmissible or set it aside. And if the IPO recommendation is not appealed, if the person accepts recommendation, or if the IPAT affirms the recommendation, then the logical consequence or the outcome is one way. The minister shall determine the application to be inadmissible under subsection 11. So it's a mandatory requirement at that point. The effect of the determination that an application is inadmissible is that it terminates the examination of the person's application for international protection. There's no requirement to prepare section 39 reports and so on. It simply brings the application to an end. Now, at the time, or prior to quite recently, where a person was the subject of the inadmissibility procedure, their application was terminated under the 2015 Act, but the pathway thereafter wasn't particularly clear or well thought out, I would say, and effectively, the only option that was therefore available was the Section 3 process, the deportation process. And that is what happened in the MAH, and we've heard Anne's very compelling account of her client's experience in that case. I'm very grateful to her for that, because I agree with Colin, it's so important to hear the reality of this for people who experience it. So MAH was the subject of an inadmissibility finding because she had been granted refugee status in Hungary. She was thereafter told the only way she could seek to regularise her situation in Ireland was by making an application for humanitarian leave to remain. So effectively going into the deportation process and hoping to persuade the minister to grant her permission to remain on a humanitarian basis. It took more than 2.5 years for that application to be determined, a delay that's not at all uncommon in my experience in the processing of deportation cases. And during that period, as Anne has mentioned, she was excluded from direct provision without permission to work and without any means to support herself, effectively relying on charity and the kindness of others. Ultimately, at the end of that 2.5-year period, the minister made a deportation order, and the High Court in the judgment quashed the minister's decision, saying that there had been a lack of engagement with the country of origin information detailing the situation in Hungary. We're all, I'm sure many of us, aware of the situation in Hungary and continue to observe with considerable alarm the situation in Hungary. The minister had effectively said, Hungary is a member state, we therefore assume that they're complying with human rights obligations. And the judge said that that really didn't deal with the reality of the COI, which demonstrated the rise of xenophobic attacks and various other concerns. It's fair to say the High Court judge was not impressed with the treatment of MAH's application, and in unusually, I think, strong language, she concluded her judgment by saying that it seemed to her that the founding architects of the system of international protection in place in Europe today would be of the view that we as a people have badly failed the applicant in this case, And I think while it's a very important judgment, and it's one that really emphasises to the Minister for Justice in applying the consequences of a finding of inadmissibility and the assessment of risk to an individual in those circumstances, I think it's important to note the judgment doesn't deal with the fact that for those 2.5 years, MAH was left in this situation of being without access to any means of subsistence or support. And that remains an issue, notwithstanding the reforms that I'm about to come to. So I think it's a very important judgment that highlights really one of the very worrying features of the inadmissibility procedure. So turning then to post-Brexit, the inadmissibility procedure was amended by the withdrawal of the United Kingdom from the European Union Consequential Provisions Act of 2020 by adding a new third category of inadmissible applications. And that is where the person has arrived in Ireland from a safe third country, which is a country in accordance with, that meets the conditions set out in subsection 17 as a safe country for that person. And the Minister has, under the legislation, the power to designate by statutory instrument countries as safe third countries, where the Minister for Justice is satisfied that that country meets certain conditions. And to date, the UK is the only country that has been designated as a safe third country. We do have, as Nick mentioned, a list of safe countries of origin, but the UK is, as far as I'm aware, at least at the moment, the only safe third country that we have in Ireland. And that is clearly intended to take account of the fact that the Dublin transfer procedure is no longer available. The Withdrawal Act also inserted new section 72A into the International Protection Act. This is really just to ensure compliance with the Procedures Directive in terms of the criteria for designating safe third countries, in terms of the requirements of non-refoulement, prohibition on torture and so on will be respected. And in particular, that the possibility exists to request refugee status and if found to be a refugee to receive protection in accordance with the Geneva Convention. And I'll come back to that because that's potentially, I think, quite important in respect of the designation of the UK, certainly going forward. The criteria for designating a safe third country for a particular person, again, partly derived from the directive. The person must have a sufficient connection with the country on the basis of which it's reasonable for him or her to return there. That the person will not be subjected to the death penalty, torture, inhuman or degrading treatment or punishment in that country, and that they will, again, as a matter of practice, be readmitted to that country. And further detail is set out then as to what constitutes the sufficient connection. So the period the person has spent, this is in subsection 18, the period the person has spent, whether lawfully or unlawfully in that country, any relationship between the person and other people in that country, including family members who may have applied for asylum there, or other family members who may be resident on alternative bases, and the nature and extent of any cultural connections between the person concerned. So those are the guiding criteria in deciding whether the United Kingdom is a safe third country for a particular applicant, and that will require some engagement by the decision makers with the facts of the individual case. So I've already mentioned the procedure whereby if the IPO considers that there may be grounds for applying this inadmissibility procedure, they make the recommendation, there is the right of appeal. And ultimately, if the decision is made to uphold the recommendation of the IPO, then the Minister shall make the determination that the application is inadmissible. The question is what happens then? As we saw in MAH's case, at that point in time, the only pathway forward was the Section 3 process. And that's where the Withdrawal Act has introduced this new return order procedure, I suppose, as the kind of tailpipe that now follows on. I think the intention is to follow on from the determination of inadmissibility. I will say the legislation isn't particularly easy to read. It's not quite as bad as I gather the immigration rules in the UK are, but it's certainly, this is my best attempt at summarising the new rules, and it's also in the abstract because I haven't seen any of these in reality yet. I'm not sure if any return orders have in fact been made yet, so some of this may be subject to change once we see the new procedure actually up and running. But the Minister can go on to make a return order in respect of a person whose application has been deemed inadmissible, for example, on the basis that the UK is a safe third country. And the prohibition, there's a new Section 50A of the 2015 Act dealing with the prohibition of refoulement in respect of this category of applicants whose application have been determined to be inadmissible. So we do have a statement of the general rule of non-refoulement, which applies as a matter of Irish law. We know that that applies in the deportation context, for example, and we now have a specific expression of it in the context of inadmissible applications. The Minister is required to have regard to information submitted by the person informing his or her opinion in respect of refoulement. But what worries me in looking at the legislation is that there's no procedure that I can see here that would be equivalent to the Section 3 procedure, whereby a person is given notice of an intention, for example, to make a return order, invited to make representations. The Minister is required to have regard to the information that the person has given, presumably through the interview process with the IPO, perhaps as part of the appeal papers to the IPAT. But there doesn't seem to be any direct pathway by which, or certainly no formal pathway through which the applicant can raise matters of concern with the Minister. Now, Section 50A, subsection 3 does say that if a person becomes aware of a change of circumstance that will be relevant to the Minister's decision on refoulement, he or she shall inform the Minister forthwith of that change. But again, I don't see any procedure here. So effectively, I'd imagine it's intended that a person can simply write a letter to the Minister to say there has been a change in terms of the situation in the safe third country, for example, that it's proposed to return me to. I don't think that's particularly satisfactory. It reminds me of the Article 17 debacle that we've had, whereby the Minister now is found to have a power, but there's no apparent procedure by which a person can really raise those issues other than by making submissions in correspondence, which may or may not ever actually result in any response. But it seems to me that that's how this is intended to operate. It's also worth noting there that the subsection 3 is limited to a change of circumstance, and this is quite a narrow formulation. So, for example, if there's an error in the IPO recommendation or an error in the tribunal's decision, that wouldn't appear to be something that can be dealt with by way of this Section 50A subsection 3 procedure. It's only a change of circumstance, and a similar issue has caused problems in the Section 49 procedure because of the way in which the review process operates there. So that's just something that occurred to me in reading this. If the Minister, subsection 4 says that if the Minister believes that a person who would ordinarily be the subject of a return order, but in fact should not be made the subject of a return order because of, the principle of refoulement is engaged, that it would violate the prohibition on refoulement to make the return order, then effectively the person is admitted back into the process. They are deemed to have made an application in accordance with Section 15, and they therefore resume their pathway through the international protection process here in Ireland. But again, it seems the way the legislation is drafted seems to me that this is the Minister effectively conducting this process really without engagement directly with an applicant themselves. And personally, I'm concerned about that, and I'm concerned that may result in issues being missed and ultimately unsatisfactory decisions being made. But we will have to, as I say, wait and see what happens. The Minister is only required to notify a person in writing if he or she decides effectively to allow them to remain in Ireland and to allow their application be processed in Ireland, notwithstanding the finding of inadmissibility. The person is entitled to be notified of that fact under subsection 5. Presumably then in the reverse, if the Minister doesn't believe that the principle of refoulement is a barrier, then effectively what will happen is that the person will be the recipient of a return order, and that's what I'll deal with next. So Section 51A, again inserted by the 2020 Act, says that the Minister shall make a return order in respect of a person whose application has been deemed inadmissible. So this doesn't appear to be discretionary. There doesn't appear to be the same scope for humanitarian leave to remain that we have under Section 3 of the Immigration Act. I know chapters written in admin law books about when shall can be read as may, and that might be something that we have to argue out, but on its face, it appears to be in mandatory terms. That's also, I think, potentially concerning because there may be situations where it's not a refoulement issue, but there are other human rights considerations at play. If the person, for example, has family members in Ireland, there may be constitutional family rights, Article 8 type rights that may be engaged. And while they may be only rarely capable of preventing a removal, nonetheless, on the face of this legislation, they're not a barrier at all. The Minister is actually not required to have regard to them. And there are all sorts of questions, I think, in terms of ECHR Act compliance there. The power to make the return order is obviously, again, made subject to the prohibition on refoulement in Section 50A. And if the Minister is, as I say, the only barrier effectively to making the return order in respect of a person whose application is inadmissible is if the Minister believes that it would actually violate the prohibition on refoulement. Otherwise, the Minister shall go on to make a return order and may return the person either to the member state which granted them refugee status or subsidiary protection, or to the first country of asylum, or for our purposes, what we're particularly talking about today is the United Kingdom, where the Minister has decided that it is a safe third country for the individual concerned. Written notice has to be given to the person of the making of the return order and their legal representative. There's no time limit in the legislation for how long the minister has to make decisions on the return order. And while I'm sure it's intended that it would operate quite swiftly, as we saw in the MAH case, although that was in the Section 3 process, it's not, certainly in my experience in the immigration system in Ireland, these processes can often take much longer in reality than they're envisaged at the policy development stage. And so there is no time limit in place for the minister to make the actual return order itself. The form of the order, just again, these are more minor issues, I suppose, has now been prescribed by regulation. If anyone's interested, that is the form of the order. And Section 51B then of the Act goes on to deal with procedural aspects for securing the physical return of the person where the return order has issued. So again, quite similar powers as would exist in respect of deportation orders. A person can be required to report regularly to their local immigration officer or to GNIB in Dublin. The person may be required to surrender their passport or cooperate with obtaining new travel documents. They may be ordered to reside at a particular place and not to leave that place without permission or notifying of that change. There's also a power to arrest without warrant and detain a person who's the subject of a return order for up to 7 days, where an immigration officer or a member of the Garda Síochána consider that there is a serious risk of the person absconding, and the legislation sets out factors that have to be considered in determining that risk, such as misrepresentation or omission of facts in relation to identity, including but not exclusively the use of false documents, failure to comply with reporting requirements, residence requirements, or the requirement to surrender documents or cooperate in applying for new documents, failure to cooperate with arrangements for return, if the person has explicitly said they're not going to comply with the arrangements for their return, or previous failure to comply with the law of the state or of another state relating to the entry or presence of foreign nationals. And I suspect that one in particular could potentially be used in many of the cases where we've seen we have in recent years, in my experience, seen a significant enough cohort of people coming from the United Kingdom, either as timed out students or after the English language test scandal. And so that last ground in particular may actually apply in a significant number of cases. So while there is no time limit for the making of the return order itself, the reason why I say I think it's intended to be expedited is because they have a shelf life. Section 51C says that a return order will in the first instance be valid for 6 months from the date of notification. So there's a clock running, and I presume the intention is that the removal should happen or the return should happen sooner rather than later. That can be extended up to a maximum of 12 months if the person has absconded, or if the person brings judicial review proceedings in respect of the return order, then and the High Court grants injunctive relief, then effectively it stops the clock. And the return order is valid for up to 6 months after the final determination of the courts, and that would include any appeal. So they do have a limited enough shelf life. And ultimately, if the return order does expire without the person having been returned in accordance with whichever is the relevant time frame, then at that point the person has to be effectively permitted to continue with their application for international protection in Ireland, because they cannot now be removed or returned from the state. An issue that Nick touched on in his introductory remarks is, and that also is obviously a huge issue in relation to MAH's case, was the access to reception conditions for people who are in the inadmissibility procedure. We know under the reception conditions regulations that Anne also touched on that applicants are entitled to access material reception conditions, which is accommodation, a financial contribution, and other direct material supports. The question that's arisen, it seems, so far, is that the IPO takes a view that from very early in the process, when the IPO makes its recommendation that an application should be deemed inadmissible, it seems that the IPO is taking the position that the application is from that point in time inadmissible, and the person is therefore no longer an applicant. And therefore, the consequence of that is that the person is no longer entitled to reception conditions. So that's the logic, and that's the approach that the IPO is taking. That is not compatible on my reading of the legislation, either as a basic matter of statutory interpretation, and I don't think it's compatible with the Reception Conditions Directive either. The IPO makes a recommendation. It does not make a decision. That's in the language of the Act itself. The IPAT either affirms the recommendation or sets it aside. Again, it's not making the determination. The determination is only made by the Minister at the end of the admissibility procedure. That's the language of the Act on its face, plain and literal meaning. So I think the IPO is incorrect. As Nick has said, the Refugee Council are engaging with the IPO on this, but whether if the IPO doesn't change course on this and accept that they have been misinterpreting the legislation, I think that is likely to result in litigation.
Patricia, just to mention that there are
Over time,
a couple of more minutes, yeah.
I'm nearly finished. Thanks, Colin. Even if this issue is resolved, and even if the IPO accepts that a person is entitled to remain in direct provision until the actual determination itself is issued by the minister, there will still remain, I think, there is a concern that people will still end up in the situation that MAH did, because once the minister determines their application, the minister, I think at that point, will say, well, you're definitely no longer an applicant at this point in time, and the person may at that point be the subject of withdrawal of reception conditions. But there's no timetable or no time requirement for the making of the return order, and the minister has 6 months then from the making of the order to actually give effect to it. And so the question still remains about what happens to people in that situation, and whether we're going to see other people in the very unfortunate situation that MAH did, in terms of absence of material supports and reliant on charity and the support of others. I've referred to the Adam Limbuela and Tassima case. It was a very different context in terms of asylum seekers in the UK who had failed to make their applications as soon as reasonably practicable, and that had an impact on their ability to access supports. But there may be human rights Article 3 type considerations engaged in these cases. So I just wanted to mention that, because if litigation does arise, that there may be some assistance to be derived there. So just in terms of conclusions, the new inadmissibility procedure, which is to replace the Dublin procedure, is much narrower in the way that it operates in a number of respects. In particular, it doesn't mirror all of the Dublin rules. We don't have the humanitarian exception, for example, in Article 17. I think I have some concerns about the procedure for the assessment of refoulement, and the way an applicant can engage with the minister around that, and the lack of any ability to take into account those humanitarian circumstances. I think the designation of the UK as a safe third country needs to be kept under review in light of the proposed asylum reforms, which I think Adrian is going to speak to. But the ability to make an application for an asylum in the UK and the way that person will be treated are central to the designation. So in the light of Priti Patel's latest reforms, which may or may not happen, but I think it's very important to keep an eye on those. There, I think, remains a very serious concern about the limitation of access to reception conditions for people who are in the inadmissibility process. I'm sorry for going over and for probably bamboozling people, but I'd be very happy to take any questions if anyone has any at the end.
Thank you very much, Patricia, for that really comprehensive analysis and raising a number of specific concerns as well, which we can take up at the questions at the end. Just reminding our audience this afternoon that if you would like to ask a question, please put your question in the chat box, and we'll pick up those questions and we'll have a discussion at the end of the seminar. So thank you again, Patricia. Our next speaker is Adrian Berry. He's going to be talking about removal policy, safe countries and bilateral agreements, and a critique of the UK's plans. Adrian is a barrister at Garden Court Chambers. Adrian's practice spans a range of interrelated public law areas, including citizenship, immigration, human rights, international protection, and social assistance. He's also the patron of the Immigration Law Practitioners Association. Adrian.
Thank you very much. And I'd like to thank the Irish Refugee Council and the Law Centre of Northern Ireland for this opportunity to speak to you about the position we're in as regards returns following Brexit. Despite this isn't a political presentation, but there is one observation I would start with at the outset, that despite in a sense the political direction or trend of the current government towards doing things on a sovereign basis on their own, there are certain aspects of European cooperation that they've always sought to maintain, and one of those was the Dublin system for transfers, not because they wished to bring unaccompanied minors to the United Kingdom, but because they wished to export asylum seekers to other European countries. And it's been a feature of the Brexit process that the UK has consistently tried to maintain those arrangements, even to the extent of preparing a draft treaty, which it had hoped to negotiate with the European Commission last year. It failed to do so because the Commission had no mandate to negotiate such a treaty. And throughout the year continued essentially to assume the ostrich position as regards the expiry of the Dublin 3 regulation in the United Kingdom by putting its head in the sand and ignoring it. And so a number of asylum seekers who arrived in the UK, having journeyed through other European Union countries, were treated as Dublin arrivals, in other words, not to have their asylum claims processed in the UK. And throughout 2020, the United Kingdom's position was that they were going to return them, and indeed they often were detained for the purposes of return and removal to European Union states on the basis that the Dublin regulation continued to apply. And so there were a number of challenges brought to that, to those individual cases of return in the High Court in England and Wales, and the idea was that the UK continued to expect that European Union states participating in the common European asylum system would, and I quote, honour their commitments in respect of the Dublin regulation. Well, the difficulty with all of that, essentially, was that the Dublin regulation doesn't form a part of international law as such, as in a treaty between individual states. It's a piece of rulemaking within the European Union legal order, and it was destined always to expire in UK time at 11 p.m. on the 31st of December of 2020. That was highly predictable because that's the end of the transition period in UK time, and so that was going to be that. Despite that, the UK continued to proceed with Dublin removals and to try and attempt Dublin removals. And so in 2021, as the new year dawned, they were continuing to try and do that. And the result of that was that people were continuing to be detained, asylum seekers who'd arrived in the UK for the purposes of removal. It then became apparent that other EU countries or EU states were not had no interest in maintaining Dublin arrangements, not because they were necessarily being difficult, but because the Dublin system is, of course, a system of law, and there is no law as between the UK and the European Union states anymore, because the Dublin regulation lapsed in the United Kingdom's own legal order with UK withdrawal from the European Union. And so we've had the rather difficult and unattractive situation where there have been asylum seekers in the United Kingdom who've been detained for the purposes of removing under Dublin, when in fact there is no law there. And in that context, it's in that context that the UK has been seeking to make bilateral arrangements with other states, and has not succeeded in doing so. There are examples of returns arrangements on a bilateral basis. It's not necessarily solely a matter of European Union competence to negotiate asylum seeker returns. And you can look at arrangements between, for example, Hungary and Serbia in that context. But what the UK did not succeed in doing in 2020, and has not succeeded before the end of the Brexit transition period, and what it has not succeeded doing in 2021, is negotiating with countries such as France or Belgium or Germany or Spain, bilateral arrangements akin to the Dublin arrangement, nor has there been any appetite within the Commission itself to negotiate any such arrangements. And it's in that context that the UK immigration plan falls to be considered. It's a sort of plan B, if you like. Plan A, if it was possible, was to maintain those aspects of Dublin. But obviously the Dublin returns procedure sits at the centre of the common European asylum system. And obviously I don't need to tell anyone on this call that obviously that includes common reception standards, procedure standards, and the qualification directive, and so on and so forth. And it sits, and so there is effectively, it is an aspect of European solidarity. And that's precisely, of course, what the UK has chosen in its wisdom to reject on leaving the European Union. And so we end up in the position where they genuinely appear to be shocked on one level that these arrangements don't no longer apply, and that there is a lack of appetite for bilateral returns agreements on an individual basis between the states with which the UK has most interest in exporting asylum seekers who arrive having made the difficult journey to the UK across largely continental Europe. So that's the sort of context in which you have to look at a number of things. One, the forthcoming UK Sovereign Borders Bill, which may well seek to look at cross-channel crossings coming to the UK and repeat asylum claims, and also the UK's new immigration plan with its attempt to further tighten asylum procedures, and also to look at making it more difficult for lawyers to represent asylum seekers and refugees. And so that's the setting within which it falls to be considered. And it's always very difficult to understand whether or not the UK truly believes it can negotiate bilateral arrangements with individual European Union states, or whether it can or whether it actually is, that's if you like, a feint just for domestic consumption, and that actually really at the heart of it are the new restrictions on the ability to claim asylum that are already contained in the statements of executive policy which form the UK's immigration rules, and which may well find themselves being worked into in the statutory form in a new UK sovereign borders bill. So there may be something effectively which is put out there, if you like, for political consumption, and then other in terms of, well, we are attempting to negotiate bilateral sort of Dublin type arrangements, even though there's no appetite, no counterparty, if you like. But the real substance of it is in domestic UK policy and domestic UK statutory provisions, which are forthcoming. And you can sort of, and it leads to some bizarre consequences, because of course the Dublin regulation would have formed part of retained EU law in the UK under the statutory provisions under the EU Withdrawal Act of 2018, as amended by the Withdrawal Agreement Act of 2020, if no other steps had been taken. So although it was directly applicable without the need to transpose it into domestic law because it was an EU regulation, at the same time, obviously at the end of the transition period, it would have formed part of retained EU law, because of course there are a lot of EU laws which just had to be downloaded, if you like, into the UK statute book in some form in order to maintain a working system of rules at the end of the transition period. But it was repealed by a particular statutory instrument, the Immigration, Asylum and Nationality EU Exit Regulations, which is a Westminster form of subordinate legislation, and so it no longer applies. There were transitional provisions which were put into those regulations, but they were all about continuing to, in cases where there were family reunion provisions, to bring children to the UK that were already in hand at the end of the transition period. The transitional protection applied in those circumstances. There was no transitional protection for the export of people, if you like, asylum seekers from the UK to other countries. And so, so the difficulty is, and you can see therefore in the statutory provisions and in the statutory instrument made on in order to give effect to the end of the Brexit transition period within this area of activity, that it was absolutely plain that there was nothing to replace it. But the peculiar thing about the way in which it's come to be, and I'll come on to it in a moment, it is that the primary way of treating UK asylum seekers who've come to the UK from other European Union countries, which is found in Schedule 3 to the Asylum and Immigration Treatment of Claimants, etc. Act of 2004, remains the same. In other words, it's as if Brexit never happened as far as primary legislation is concerned. The states, member states of the European Union, including Ireland, are deemed to be safe as a matter of statute, not as a matter of individual executive decision in an individual case, by paragraph part 2 of Schedule 3 to the 2004 Asylum and Immigration Treatment of Claimants Act. And it hasn't been changed. And so you will see cases where people are still listed for removal under a statutory procedure that they cannot bring their refugee claims, they cannot bring their human rights claims in terms of onward refoulement to a third country in the UK as a matter of statute, even though that statutory provision was drafted against the backdrop of what was then the Dublin 2 regulation, which is obviously now the Dublin 3 regulation. And that leads to some rather embarrassing situations. And in one case, which I was involved in, the Secretary of State was asked to state, so what exactly do you propose to do to the Dublin removals? To effect Dublin removal in this case, what are your arrangements with the European Union country, which was the proposed country of return? And there came no answer, and the case was settled quite quickly on behalf of the government, because there is no answer, there are no arrangements, and yet they still proceed along the lines as if there are. There was one point that I would draw your attention to, which was that there was, when the Trade and Cooperation Agreement was negotiated between the EU and the UK, the agreement which replaces membership of the European Union with this rather thinner material, there was a joint political declaration on asylum and returns which accompanied that arrangement, which merely records that the parties took note of the United Kingdom's intentions to engage in bilateral discussions with certain member states to discuss practical arrangements, which suggests that maybe an intimation that they are looking at administrative arrangements rather than legal binding obligations as a way forward in those circumstances. That raises very difficult questions about compliance with the Refugee Convention, compliance with human rights obligations as they take effect in the UK legal order, if that's to be the case. So there is a procedure within the 2004 Asylum and Immigration Treatment of Claimants Act to deal with a situation where you wish to return someone to a third country and they're not on a list, if you like, of safe countries, of the European Union list, if you like, of countries. But that requires the Secretary of State to make a decision in each case that there would be no breach of the Refugee Convention and no breach of our Human Rights Act, of the European Convention of Human Rights as it's applied in the UK via the Human Rights Act. And that's not what's going on at the moment. Return to European Union states is considered, those countries are considered safe because of a different part of the provision that Parliament has stated that they are safe, rather than because of individual consideration. And of course that creates problems. You could still argue that reception conditions in the European Union country of proposed return are unsafe on human rights grounds. So you can still argue that, you know, the point that went along the case law that Patricia was talking about in as with regards to the Limboela test, that you might be, for example, be destitute in the country of return, contrary to Article 3 of the European Convention. But what you can't, but you still, even in that circumstance, you run the risk that the Secretary of State will certify the case as clearly unfounded, and that will preclude an in-country right of appeal to the first tier tribunal, which is the Immigration Tribunal, which deals with immigration and asylum claims in the UK. So even in that narrow circumstance, that procedure exists. But by and large, the primary statutory framework maintains itself unamended. In that context, cutting across it, if you like, there have been changes to the UK immigration rules, which are the statements of executive policy, so that an asylum claim, if you've come from a so-called safe third country, won't be considered if you could have made an application in a safe third country. You didn't do so, and there are no exceptional circumstances why that application could not have been made. If you then, therefore, the UK will decline to consider your asylum application under the immigration rules at present, even though there are no actual removal arrangements as a matter of law between the UK and the proposed third country of removal. So say, for example, you travel through France to come to the UK. If there are no exceptional circumstances in the Secretary of State's view as to why you didn't claim there, she will decline to consider your asylum claim. But there is no Dublin arrangement for the transfer and processing of that asylum claim in France. But the immigration rule will still lead to blocking your claim. And then you have to then, under the immigration rules, wait until she judges, if you want your claim to be decided in the UK, that within a reason that removal to France within a reasonable period of time is unlikely. So she has to decide what a reasonable period of time is, and that removal is unlikely. In other words, if you want an asylum claim decided in the UK, you have to wait until the Secretary of State exhausts her energies trying to remove you to France, a country with which the UK doesn't have a bilateral arrangement akin to the Dublin regulation. And so you end up in limbo, and in practical terms, you're going to end up being detained unless you can get bail until such time as effectively she gives up. And so that, rather regrettably, is where we are. And I noted with interest the arrangements made in the context of Irish legislation, because it seems to rather support the idea that practical arrangements are what the UK is trying to realistically get involved in. It's also trying to leave people who are effectively recognised as in needing protection, or at least cannot be subject to refoulement, in some kind of temporary status, rather than granting them formally asylum in the UK and recognising them as refugees and regularising their status through grant of asylum. So it's all a bit of a mess. Not for the first time I've had to give a presentation on Brexit, whether it's in the field of economic migration or in restricted protection, where it's all a bit of a mess. It seems like the most accurate summary of where we are, but that is where we are, unfortunately. And I would welcome any colleagues' shared experience of what's happening from your perspectives as well, because it's very difficult to find our way through the thicket. So yeah, thank you very much.
Thank you very much, Adrian. Thank you, Patricia and Adrian, for wonderful presentations, great practical insights, comprehensive analysis. All a bit of a mess, probably captures things wonderfully well, but also, as everyone knows in this conversation, it's a mess with really serious consequences for people. And I suppose one of the things that really struck me listening to the discussions this afternoon is that the lack of general public awareness of some of these questions. You know, the human component of Brexit on this island, these islands, human rights, human dignity components being left out of a lot of the public conversation. So we've asked people to share their questions in the chat box, and we'll, feed those through.